There is a sequence of events from Monday that I want to walk through very carefully. Because when you line up every step in order, the legal structure of what happened becomes impossible to ignore. Step 1. In January 2026, Donald Trump filed a $10 billion lawsuit against the Internal Revenue Service. He filed it in his capacity as a private citizen. The defendant was the federal government, the government Trump controls. Step 2. On Monday morning, Trump's attorneys informed a federal judge that the president was voluntarily dropping the suit. Step 3. Within hours of that filing, the Department of Justice announced the creation of a $1.776 billion fund, the Anti-Weaponization Fund, to compensate people who claimed they were wrongly targeted by the previous administration. Step 4. The judge overseeing the case, U.S. District Judge Kathleen Williams, issued an order closing the case. She wrote that she had been stripped of jurisdiction to continue. What you just read is the complete structure of what the Trump administration is now calling a settlement. Let me explain why that word is legally significant and why the judge's earlier conduct in this case matters for understanding what happened Monday. Judge Williams had been raising questions about this lawsuit for weeks. She had noted that the case presented an obvious structural problem. The president was suing a government he controls. Basic legal principles require that the parties in a lawsuit be adversarial. The government and the president it is run by are not adversarial parties. She ordered both sides to file papers justifying that the case could legally proceed. She appointed outside attorneys to weigh in on the ethics and legality of the arrangement. She had set a deadline for Wednesday for those papers to be filed. On Monday, before that deadline arrived, the case was dropped and the fund was announced. The deadline that would have forced a public legal reckoning with the structural problem was never reached. Representative Jamie Raskin put the constitutional issue in specific terms. He said no one can be both plaintiff and defendant in the same case. He said no president can file a case for $10 billion against the government he controls, then settle that case against himself as judge. He said this is not a genuine case or controversy as required by the Constitution. He called it a racket designed to take $1.7 billion of taxpayer money and pour it into a slush fund for Trump to distribute to allies, January 6th defendants, rioters, and those who beat police officers at the Capitol. Those are strong words, but the structural facts underneath them are not in dispute. The fund was established using money from an existing government account for paying administrative claims, $1.776 billion. The number was chosen deliberately, a symbolic reference to 1776 and the Declaration of Independence. The fund will process claims through December 15, 2028. That date is 1 month before Trump's second term ends. The fund is run by a 5-member commission. Every member is appointed by the Attorney General. Trump can remove any member at any time. The Attorney General who announced the fund is Todd Blanche. Before becoming Attorney General, Todd Blanche was a member of Trump's personal legal defense team. There are, according to the DOJ, no partisan requirements to file a claim, but the president himself, when asked by reporters who would benefit, said the fund was designed to reimburse people who were treated brutally. He mentioned legal fees. He said it would all be dependent on a committee of very talented, very highly respected people. Asked whether people who committed violence against Capitol police officers would be eligible, Trump said, "It'll all be dependent on the committee." He did not say no. Mike Lindell, the Trump ally and MyPillow founder, told CNN he expects to be compensated from the fund. He said his employees deserve to be made whole. A group of 93 House Democrats filed an amicus brief the same day calling the settlement collusive litigation, designed to force the American people to put money into the pockets of the president, his family, and his friends. They used a specific legal term, collusive. A collusive lawsuit is one in which both sides are coordinating rather than genuinely litigating. That is not a political characterization, it is a legal concept that carries consequences if proven. Citizens for Responsibility and Ethics in Washington called it the most brazen act of self-dealing in the history of the presidency. Senate Minority Leader Chuck Schumer said no president should be able to use the Department of Justice as a personal rewards program for people who helped him attack democracy. The DOJ said the fund is modeled after a 2010 settlement in which the Obama administration compensated Native American farmers who had been discriminated against through federal loan programs. That settlement was $760 million. It was reached after years of litigation over documented federal discrimination. It was not structured as a presidential lawsuit against the government the president controls. Here is what the public record now shows. A sitting president sued his own government for $10 billion. A federal judge raised structural legal objections and set a deadline for the parties to respond. Before that deadline arrived, the case was dropped. A $1.776 billion fund was immediately announced, controlled by an attorney general who was previously on the president's personal legal team, with a commission the president can fire, processing claims until 1 month before his term ends. 93 members of Congress called it collusive. The president said violence against Capitol Police might be eligible for compensation depending on the committee. That is the public record as of Monday. Representative Raskin called it pure fraud and highway robbery. The question that the judge was about to force both parties to answer in public was never answered. The deadline passed before the fund was announced. Now the deadline is gone. There is one more structural detail that has not been widely reported. Trump also withdrew, as part of the same settlement, his administrative claims for damages related to the DOJ's criminal cases against him. That means the settlement did not just resolve the IRS lawsuit. It resolved Trump's personal claims arising from the January 6th prosecution and the classified documents case simultaneously. Both of those cases were dropped when Trump returned to office. He had filed administrative claims for damages stemming from those prosecutions. Those claims are now also gone, folded into the same settlement document that produced the fund. A single agreement closed 3 separate claims against the government at once. The settlement document that accomplished this was filed by the same DOJ that is now administering the fund that emerged from it. The judge had been asking whether there was a real case or controversy here. She never got her answer. What she got instead was a motion to close the case, which she granted, noting she had been stripped of jurisdiction. The constitutional question she was trying to force into the public record, can a president sue and settle against himself using taxpayer money, is now sitting unanswered in a closed federal docket. Democrats have filed a motion to intervene. Whether a court will take that motion up with the case already closed is itself an open legal question. The fund will distribute money for the next 31 months. The committee has not been named, the criteria have not been published, and the president said it will all depend on the committee.